Good morning, good afternoon, or good evening. This is our first practice session in 2024. I hope that everybody has had a relaxing break, and I wish you all a peaceful, productive, and prosperous year. In my speech today, I will be talking about public domain, how it is defined, and what types of intellectual property may fall into the public domain, and in what ways. The term public domain is used in relation to copyright, which is a type of intellectual property. Copyright laws apply to creative works such as books, paintings, music, movies, as well as software. The terms intellectual commons or information commons are sometimes used to express a similar idea. These terms refer to space, physical or online, where knowledge and information can be gathered and preserved for the benefit of the public. So, under the Berne Convention that was first adopted in 1886, the moment a creative work is physically recorded in whatever form, its creator or author automatically owns the copyright, not only to the work itself, but also to any derivative work, such as translation, screen or stage adaptation, or a musical arrangement, if this is a piece of music. The word copyright literally means the right to copy, but there are other things that are covered by copyright. A creative work may not be displayed, distributed, altered, or commercialized in any way without getting an explicit permission from either its creator or anyone who presently owns the copyright. However, there are creative works that are not subject to copyright laws. Such works are said to fall into the public domain. This means that anyone can legally use, reproduce, redistribute, display, or modify the work freely without having to obtain the copyright holder's permission first. The first known Copyright Act was passed in 1710 by the Parliament of Great Britain. And so all the original works that were created prior to 1710 automatically fall into the public domain. This includes, for example, works of William Shakespeare or Leonardo da Vinci. But those works that are initially protected by copyright laws, in time can also find their way into the public domain. And there are four ways in which this can happen. First, this can happen when the original copyright expires. The term of copyright protection varies from country to country and depends on a number of factors, such as when the work was created, whether the author is known, whether the work was published, and if so, the date of its first publication, and whether the work was commissioned and paid for. For example, in Canada, as of December 30th, 2022, the term of copyright lasts for 70 years after the death of the author, if the work was published during the author's lifetime, or for 70 years after the year of first publication, if the work was first published after the author's death. In the US, works created after January 1st, 1978 are protected by copyright laws until the death of the author, plus an additional 70 years. If the author is unknown, or if the work was created for hire or was commissioned, the copyright lasts for 95 years since the year of first publication, or for 120 years from the year of its creation, whichever comes first. Some of you may be familiar with Project Gutenberg. This is an online collection of more than 70,000 free electronic books. These works are no longer protected by copyright laws because their authors had died over 100 years ago. Project Gutenberg contains books by Elizabeth Gaskell, Edwin Abbott, Sir Arthur Conan Doyle, and many others. Interestingly, each individual work published as part of Project Gutenberg does fall into the public domain and may be used freely without permission. However, Project Gutenberg itself is what is referred to as a collective work, and as such is subject to copyright laws. In other words, collecting, scanning, and uploading all those books, as well as designing the website, constitute a creative work which is owned by the authors of the project. So second, a creative work falls into the public domain if the rights have been forfeited. This happens when the copyright holder does not renew the copyright on time. For example, in the US, if the work was first published before 1964, the copyright owner had to renew the copyright during the 28th year after publication. And whenever the author failed to apply for renewal, the copyright was lost and the work became public property. Third, sometimes the creator or the copyright holder may expressly waive their rights. They may choose to deliberately dedicate their work to the public domain. If, for example, you're holding a book and this book contains a notice saying this work has been dedicated to the public domain, you may legally use it without having to obtain permission. You may translate it and publish the translation. You can make it into a movie or into a play. You can distribute it. And none of this would constitute copyright infringement. However, not all legal systems provide such a straightforward mechanism for dedicating works to the public domain. This is the case, for example, in Europe. In these jurisdictions, a copyright owner can issue a public domain equivalent license that grants as many rights as possible to the general public. Creative Commons is an international nonprofit organization that helps copyright holders to do just that. The mission of the organization, according to its website, is to promote ethical, inclusive, and purposeful sharing that serves the public interest. Creative Commons has developed 6 different types of public domain equivalent licenses, and each of those licenses specifies a set of different conditions under which a copyrighted work can be used. And then a creator or a group of creators can decide which protections to place on their work. There's another example of a public domain equivalent license. This is WTFPL. This license was released in the year 2000. It grants permission to copy, distribute, and modify software. Its authors definitely had a sense of humor, and I think they must have been really frustrated with rules and regulations around software use. The WTF portion of the abbreviation stands for what the fuck. And the full name of the license reads, do what the fuck you want to, public license. So, and finally, certain things fall into the public domain because they may not be copyrighted. This includes, for example, titles of movies or books, ideas, facts, or scientific theories. Existing individual words or expressions are not protected by copyright laws either, because they're not created by anyone in particular, and because they're not unique. For example, Donald Trump tried to claim ownership of his famous catchphrase, "You are fired." To be clear, he tried to register it as a trademark, which is different from copyright. It's a different type of intellectual property. But this phrase was not created by Donald Trump, and it had been used by others long before he started saying it in his reality show. So his application was denied. Some people advocate for the idea of perpetual or indefinite copyright. Their basic argument is that intellectual property rights should be viewed in the same way as any other property rights, rights that apply to material or tangible goods. If you own a house, for example, there is no limit, there's no time limit on your ownership. No one can take your house away and make it public property because a certain number of years have elapsed since it was first designed or purchased by you. At any point, you have a right to sell it, give it away as a present, or leave it in your will to your children or anyone else. And so it is argued that the owner of intellectual property should have the same perpetual rights as the owner of a house. But critics of the idea of perpetual copyright argue that you cannot really compare intellectual property rights and rights to material goods. They say that at the end of the day, copyright expiration benefits society in a way that expiration of material property rights would not. Creative works can be freely enjoyed by millions of people at the same time, including the author or the author's descendants. A house, on the other hand, may not be freely used by millions of people at the same time, while continuing to benefit the original owner as well. This debate has been going on for over 100 years. For example, among the proponents of perpetual copyright was Mark Twain. At the moment, however, most countries have copyright laws that set a time limit on the term of copyright. And the perpetual copyright may only be granted under special circumstances. When we have copyright versus public domain, this potentially creates a gray area where abuse is possible. And this is my final point that I'm going to address in my presentation today. For example, Getty Images, a visual media company and a supplier of stock images, allegedly has been involved in copy fraud. The business model of this company is that it purchases images from individual photographers or institutions, and then if you want to use those images, you have to pay a licensing fee. Currently, Getty Images has a library of over 450 million digitized images. So apparently, I've been reading that the company has been taking images from the public domain and then selling fake copyright licenses to those images. So as you can see, the issue of copyright versus private domain is fairly complicated. There were many details and nuances I couldn't understand myself when I was preparing this speech. For example, it is not entirely clear to me what residual rights are. That's why there are lawyers whose area of specialization is copyright. But hopefully I've managed to give you some basic idea about the topic without creating too much confusion. Thank you.